All right. Well, good afternoon, everyone, depending on where you are located. Thank you so much for joining me this afternoon. And we're here to get started on a Board of Pharmacy webinar, and this is a three-part series, and today is going to be the first part. And just a few things about the whole idea behind the series. Broke this down into three parts because there's a lot to cover when we talk about Board of Pharmacy actions. And I'll get into a little more detail about why we even chose to do this series of webinars. So as we get started here, just start with the brief disclaimer. And the main thing I would say is that, I work with Frier Levitt as an attorney, and I've been working in this space for many years, but just always want to point out that I would encourage everyone that this is really not legal advice, it's certainly not in the formal sense. So we would encourage anyone that has any issues with Board of Pharmacy actions in any way, shape, or form to definitely seek out their own independent legal advice. But we do want to offer some more practical guidance and tips through this webinar. And just a little bit about Frier Levitt. If you're not familiar with Frier Levitt, we're a national boutique healthcare and life sciences law firm. So our area of practice is pretty much exclusively focused in the healthcare and life sciences space. And as a result, we have a lot of opportunities to work closely with providers and individuals in the life sciences space, which includes a very large number of pharmacies and pharmacists, as well as pharmacy technicians. And then just briefly a little bit about myself. I've been with the firm just about 7 years. I'm a partner here, and most of my work is focused in the areas of litigation or in what I would call quasi-litigation matters. And I would say that Board of Pharmacy falls into that category of quasi-litigation. And we can talk a little bit about what I mean by that and some of those implications. And I have found that over the years, working in this space is one, particularly interesting, but also very rewarding in having the opportunity to work closely with healthcare providers. Now, the overall goals for this series is, one, I just kind of want to give a little more insight from my experience and what I've observed in this particular space about what state boards of pharmacy are and how they function, and certain qualities or characteristics of boards of pharmacy that make them unique and distinct from, I would say, two things. One, other entities that you may deal with very often, and mainly what I'm referring to are the major payors, PBMs, insurance companies, so on and so forth. And also how they're different from other government entities that you may interact with, or perhaps you don't interact with them, but may be familiar with them in other situations. An overall goal, and this is going to start in our discussion today, why it is important to be proactive in dealing with boards of pharmacies. And I would say if there's a couple of themes that I'm going to develop throughout the series and today, it's the importance of being proactive. Also, steps that you can take to develop a positive relationship with boards of pharmacy. And I would perhaps say, kind of in quotes, positive relationship, because I understand the Board of Pharmacy is what it is. So it's not necessarily the case that you're going to become close friends with them, but I do think there's a way to develop a more active, positive relationship with boards of pharmacy that can benefit you down the road. And then finally, another thing is understanding the importance of your relationship with your Board of Pharmacy and the impact that it can have on other important relationships to the operation of a pharmacy or for a pharmacist and their license. And again, getting back to primarily speaking about the major payors, PBMs, and insurance companies. Now, specifically today, I want to focus in some detail on common types of actions we see taken by boards of pharmacy, and also just a little more insight exactly what I mean by the idea of action. What are some of the common reasons for these types of actions? And also begin to understand what you can do as a pharmacy owner or a pharmacist or a pharmacy technician to decrease the chances or likelihood that a board of pharmacy will take action against you or your license. Now, I think it's important as we get into these types of things to have an understanding of just at least a foundation of just what a board of pharmacy is. And I kind of mean this from the legal sense. A board of pharmacy is an agency. And I say that because I find that this kind of goes unnoticed by many people. And many people often don't understand the implications of the fact that a board of pharmacy is an agency. Given that a board of pharmacy is an agency, they operate under a very well-established framework of rules, laws, and regulations. And when I say well-established, I mean they have a lot of leeway, a lot of discretion, and this is a well-established through statutes, laws, and regulations that are on the books, but also a lot of corresponding case law that has been developed over many, many years. The reason that I believe this is important to know is because knowing that a board of pharmacy operates as an agency, it controls how they function, but this is probably the most important part. It limits your ability as a licensee, whether it's the pharmacy, pharmacist, pharmacy technician, to challenge an action that is taken by a board of pharmacy after it has been taken. And this, again, I'm going to go back to it already. This is why one of the themes that you're going to hear is the importance of being proactive and taking preventative measures to try and prevent things from happening in the first place. Now, I know that's not always possible, and that's going to be the topic of one of the other webinars. But where possible, you want to start to develop a proactive attitude towards dealing with your board of pharmacies. As agencies, board of pharmacies have substantial authority and discretion in how they go about enforcing the rules and regulations that govern pharmacies and pharmacists or other licensees. And that is by virtue of the fact that they are the license issuers. And so the idea is because they have the authority and the ability to issue licenses, they also have equal authority to oversee and perhaps in some cases discipline the very licenses that they are able to issue. I would just mention again, I think one of the big misconceptions that I see about boards of pharmacies is that they operate much like a private company, and that if there's an issue, that the issue can just simply be worked out without any serious consequences. For example, if there's some sort of a misunderstanding or a miscommunication, or I meant to do that, but I simply forgot, I can do this now, right? And it won't be a problem. Well, the answer is it might be, but there's a good chance that it won't be okay after the fact. And so, again, given this substantial amount of authority, it is very hard to undo something once a board of pharmacy has already acted. When we talk about their significant authority, the substantial discretion and the deference, I just have here in quotes this idea of Chevron deference. This is one of the landmark Supreme Court cases. It actually goes back to the 80s that started to develop this idea of deference to agencies. And so if we fast forward to 2023, and we talk about what is the practical reality of Chevron deference as we sit here today, that is really what started to establish and cultivate this idea of legal deference to state agencies. And then getting back to the implications for you, and again, we're going to talk about common actions today. Even when we look at more common or routine actions, once the agency's acted, the ability to get that overturned is very limited. And so what is the framework? If something happens, a board of pharmacy does something that you disagree with, that you think was unnecessarily harsh, and you want to challenge that, what is an example of the type of framework or the burden that you would have to go about to undo that, so to speak, or to appeal it or challenge it? I've excerpted in this particular slide. This is pulled directly from one particular state. I won't name the state, but this and it's not really necessary, because what you will find is that as you look throughout the 50 states, this framework is very similar from state to state. It's not going to be identical. It's not necessarily verbatim, but this is a pretty good summary overview of what you're going to find in most states. An agency's conclusions will only be overturned if the agency's conclusions are not supported by substantial evidence, are arbitrary or capricious, are beyond the scope or power granted to the agency, or violate one's constitutional rights. So we might say this another way: a board of pharmacy's conclusions, determinations, orders will only be overturned if the board of pharmacy's conclusions are not supported by substantial evidence, arbitrary or capricious, beyond their authority, or violate your constitutional rights. Those are all very high bars. So assume you get an order from where there's disciplinary action taken against you by a board of pharmacy and you want to challenge it. You'd have to first be able to show that it was not based on substantial evidence. That can be very hard to do, because even though it says substantial, the bar for establishing substantial evidence is actually pretty low. Arbitrary and capricious, what the heck does that mean? It's defined, one definition says a willful and unreasonable action without consideration or in disregard of the facts or law. This is a tough burden. The idea is that you just completely got it wrong. This is just made up stuff. You had no reason to do this whatsoever. You can't point to any good reason at all. Beyond the scope or power granted to the agency, I will tell you that in board of pharmacy actions, this is highly unlikely, because if a board of pharmacy is taking action against a licensed pharmacist or pharmacy technician, there's a really good chance they're acting within their authority. You might be able to point out that there's a lack of evidence or that the action was arbitrary or capricious, but it's highly unlikely that you're going to be able to show that they were acting outside the scope of their authority. And finally, whether there was a violation of one's constitutional rights. Again, I would say here, this is highly unlikely. One little caveat to that is, in this particular space, you sometimes see this occur with monetary penalties. There are some states in the country that have within their state constitution restrictions on excessive monetary penalties. So that's one perhaps exception to the violation of constitutional rights being rare. What I would say is, even in those instances, the bar is going to be very high for showing that a monetary penalty was excessive, assuming that a state constitution provides for that protection. So, why do I go through all of that? It goes back to this idea of being proactive. To make it official, my first tip, if you haven't picked up already, is be proactive with your boards of pharmacy. And we'll talk more about what we mean about being proactive, but there's a couple of different ways. And I would say, one version of being proactive is just learning how to deal with your board of pharmacy and communicate with your board of pharmacy on a regular basis within reason, in not reserving board of pharmacy communication as I'm only going to do this when I absolutely need to. Because if this becomes a rare thing for you, it increases the likelihood that you're going to forget obligations that you have to communicate with the board. So if you get used to this, then you're more likely to not miss those mandatory reporting obligations. And then the second thing is kind of having internal proactive measures to make sure you've covered all your bases for certain obligations that you have with your board of pharmacy. I want to move now to what we see as very consistent common actions or trends by boards of pharmacy. And getting back to what I said earlier, when I talk about what were kind of the origins of putting together this series, I would say that this derived from seeing these issues most prevalent, seeing a high trend and pattern of pharmacies having to deal with these issues, which suggested to me that pharmacies and pharmacists alike perhaps need some guidance to try and avoid these types of issues. Now, for some of you, you may say, I would never forget to do that. This is easy. But I think you'll see how some of these things could easily be overlooked. And so the first common action we'll talk about is failure to notify or report. And we'll give different examples of that. The second one is failure to operate. And we can give some examples of why that can be a little tricky sometimes. And then failure to supervise or inadequate supervision. Now, when we talk about common actions, I think a good starting point is kind of reassessing how do boards of pharmacy oversee and discipline. They have a lot of different tools at their disposal and their discretion. I would say one thing that they do commonly is they review notifications or they review paperwork. Any of the documents or filings that you're required to make with a board of pharmacy, as a threshold matter, they're going to review those as they should. And I would also keep in mind a board of pharmacy's core kind of mission, if you will, is protecting the health and well-being of the residents of their state. So that is kind of their main mission. And so they're going to look for opportunities to do some basic policing of the different operators in their state. So they're going to review notifications when they receive them, and they're going to look for basic compliance. Was this particular notification given in a timely manner? Are there any omissions that we see based on this submission? One common example there would be a change of your pharmacist in charge or your supervising or managing pharmacist. If they get a notification of a new pharmacist in charge, does that notification reflect that there may have been a gap where the pharmacy was perhaps operating without a pharmacist in charge? That can immediately segue into issues regarding inadequate supervision. Another method of oversight and discipline are basic inspections. And that can go a couple of different ways. That could be an inspection associated with some sort of a change that you were required to give notice of to the Board of Pharmacy. And so they may come for an inspection based on that. It could be based on change of location. It could be based on opening a new pharmacy. It could be a random drop-in, which is permissible in many states. It could also be a result of some sort of a complaint. I would distinguish inspection from investigation. And I would kind of say that's a final good example of a method of oversight and discipline. I would say investigations are more likely to be a result of a complaint from a third party. So a patient could also be a third party payer like a PBM or an insurance company. I did want to mention, and I forgot to mention this at the start, we have the question and answer function going right now. So if anyone has any questions as we go through the program, please feel free to ask me throughout. I'm happy to field questions as we go. And I also think it makes for a more interactive experience. And on that, I did just get one question here. And it is it typical for a board of pharmacy to provide an advisory opinion on a particular topic? And what recommendations do you have for a pharmacy that would like to obtain board input on a particular topic before taking action? This is a great question. And the reason why is because it goes to that idea of being proactive. So the answer to the question of whether it is typical for a board of pharmacy to provide an advisory opinion on a particular topic is, I do not believe that it's necessarily typical in the sense that you're not going to see boards of pharmacy regularly and routinely issuing formal advisory opinions. However, I do think you will see boards of pharmacy issuing guidance, and they may try to add clarity to certain aspects of rules or regulations. So probably a good answer is it's a little bit of both. I don't know that it's going to be typical to issue formal advisory opinions, but I do think you will see boards of pharmacy provide guidance where appropriate, especially if they're seeing an issue that's frequent and causing any confusion. As far as recommendations for a pharmacy that wants to obtain board input on a particular topic before taking action, this is a prime example of being proactive. I have found in my experience that boards of pharmacy and their members want to communicate with the licensees that they regulate. And in fact, they respect this, they appreciate this, and it is a reflection of commitment to the profession in trying to do a good job. So I believe that anytime a licensee has a question and they want input from the Board of Pharmacy, they should present it to the Board of Pharmacy. Now, if it's a pretty basic issue, or you might say kind of an innocuous issue, then I think you just do it. If it's something that might be a little more complex, you might want to consider, speaking with perhaps an attorney or something like that to make sure the issue is being presented to them in the best way possible. But I really encourage that type of interaction. And I've been involved in that type of interaction, and I have found that boards of pharmacy are very responsive and receptive to those types of inquiries, of course, within reason. Now, getting back to the methods of oversight and discipline, I would mention that even routine inspections can reveal issues that may become the subject of disciplinary action. This may sound like a no-brainer, but the only reason I mention it is because I have seen instances where pharmacies will do something that they know triggers an in-person inspection from a board of pharmacy representative, but unfortunately, despite knowing that, they're not prepared for the in-person inspection, and lo and behold, the inspection that was intended for one thing, approving a change of location or something like that, leads to an observation by the inspector that something else is out of compliance. And these could be simple things. It could be, not having licensure properly posted, not having the hours properly posted for patients to see. These are minor things that can lead to, or I should say, seem relatively or seemingly minor, because I don't want to undercut the importance of these to patients and the public. But having an inspector come associated with a change of pharmacy location only to get in trouble because you didn't have licensure properly posted really seems kind of unnecessary and preventable. So on the topic of not notifying or reporting something to a board of pharmacy, common things we see: not notifying a board of pharmacy of a change of pharmacy manager, supervising pharmacist, or pharmacist in charge, not reporting a change of location, not reporting disciplinary action. You can see how the not reporting a disciplinary action can create a snowball effect as well. And I'll talk about that in a little more detail. One other aspect with all of these, there's a timing aspect of this as well. Pretty much every board of pharmacy has some sort of time limitation on this. Must report a change in location within 10 days, within 30 days. Some state boards of pharmacy require prior approval. If you're not aware of that and you change the location and report it afterwards, that could be an issue. So you want to make sure that whenever you have a change of any sort, that your kind of default position is, I need to report this to the Board of Pharmacy. So let's talk about some state-specific examples. One state-specific example arises in Illinois. And for those who don't know, but I'm sure you all do, PIC stands for pharmacist in charge. Every PIC who ceases to function in that capacity must report to the department within 30 days of the date on which he ceased such functions for such pharmacy. So in Illinois, you have a change of pharmacist in charge. You need to give notice of that within 30 days of the date of the change. That same duty goes to, or my apologies. So there's the duty on the pharmacy, but there's also the duty on the pharmacist in charge as well. So this duty belongs to both. And then they make it abundantly clear. If you don't do this, it's grounds for disciplinary action. Another example from Pennsylvania. If the pharmacist manager ceases to hold that position, the pharmacy must inform the board in writing and of the new pharmacist manager within 15 days. So in Pennsylvania, you only have 15 days. The other thing that Pennsylvania does, if there's no objection within 30 days, the new pharmacist manager is deemed approved. Now, a wrinkle in Pennsylvania, I don't know that I call it a wrinkle because I think you'll see some variation of this in most states, but here it's right in this part that deals with changes. If the permit holder is unable to replace the pharmacist manager within those 15 days, the permit holder may request in writing an extension of up to 30 additional days to obtain a replacement. This goes back to that idea of proactive communication with boards of pharmacy. And I would also say it gets back to one of the most observable trends that I've seen. A pharmacy gets into a situation where they have an issue and they're concerned about it, or they know it's an issue, but rather than being open and transparent with the board of pharmacy about the issue, they hide it or do nothing about it. I shouldn't say hide it because that assumes kind of an intent there, but it's more about they do nothing about it and only report the change once the change takes effect, even if it happens to be late. And the idea being, or the thought process is, well, I'm going to let the board know as soon as I'm able to do this. But most of the boards of pharmacy have laws or rules or regulations that understand, especially for smaller pharmacy operations, that if you have a pharmacist in charge that quits unexpectedly or leaves because of extenuating circumstances or, God forbid, passes away, that you can't just always go out and find a qualified pharmacist in charge in relatively short order. And they allow for that, but they want to know if that happens. And so communicating the issue here in Pennsylvania, if you let them know, then they will give you an extension and you can continue to communicate them with about the issue, any issues you're having. But what you don't want to do if you're having trouble replacing a pharmacist in charge is not tell them and wait until you finally hire someone and then give them the notice. Because if it happens in 16 days, 17 days, 18 days, then you have violated this rule. And once they learn about it, it's grounds for discipline, and they can and most likely will pursue disciplinary action. And then a final example here, New Jersey, whenever a pharmacist assumes or terminates the duties as a pick of a pharmacy, both the outgoing and incoming pick and the permit holder, the pharmacy, must advise the board in writing within 30 days. So 30 days is a pretty common period of time, but as we just saw in Pennsylvania, sometimes it's shorter. I would also say there's other variations, some as short as 10, which flies by. Now let's shift gears to reporting a change in location. This example comes from Texas. When a pharmacy changes location, a new application must be submitted within 30 days. The previously issued license must be returned to the board office, and at least 14 days prior to the change of location, the PIC shall post a sign in a conspicuous place indicating that the pharmacy is changing location. So there you see three obligations arising as it relates to a change of location. Perhaps the obvious one, if you're working in Texas, would be the new application requirement. That might be one that you realize right off the gate, but perhaps you overlook the obligation to return the previously issued license. Perhaps you overlook the obligation to post a sign in a conspicuous place indicating the new location. And perhaps you overlook doing that 14 days prior to the change of location. Again, another example of something that could lead to the random, or perhaps not random in a change of location, but an inspector coming along and not seeing that sign that is required, which could lead to or create grounds for disciplinary action. I would also say that this is something that can lead to a patient complaint. And now let's shift to the idea of not reporting disciplinary action. So we just talked about some standalone grounds for disciplinary action. This is the next most common one, and I can see how this can happen. And again, this would only apply typically, but again, just always be very cautious. But usually you're going to see failure to report disciplinary action for a pharmacy that's licensed in at least one other state beyond its home state. And the idea here is that if you are subject to disciplinary action of any type in your home state, there is an obligation to report that to any other states in which you hold a license. I often see this just sincerely overlooked because they're not aware that this is an obligation. I often see this not done just because of concern about, well, if I start reporting other disciplinary actions, aren't I going to just get in more trouble? And we'll talk about this, but the answer is you may get in more trouble, but perhaps the more trouble will be less if you report it than if you don't. So in Pennsylvania, any disciplinary action taken in other states shall be reported to the board within 30 days of final disposition. I think that's helpful to know that they say final disposition, because that recognizes that sometimes these things take time to work themselves out. So they want to know about final dispositions. In Illinois, failing to report within 60 days any adverse final action taken against a pharmacy that would constitute grounds for discipline as defined in Illinois can be grounds for discipline. So the idea there is if you don't report any adverse final action from another state that would also constitute grounds for discipline in Illinois, then that can also be grounds for discipline. And then in Nebraska, we see that it's within 30 days. Now, Nebraska changes a little bit, which is why I included it here. 30 days of an occurrence must report any of the following actions: disciplinary action taken by any jurisdiction, the settlement of such action, or any voluntary surrender of or limitation on any such credential or other form of permit. And so just on that reporting of disciplinary actions, the one point that I want to make is I can understand that kind of natural hesitation to report disciplinary actions. But what I would say is if you report the disciplinary action, you right off the bat have eliminated the ability of that other state board to take action against you for failing to report the action. And so you need to report this, and I would say don't hesitate to do that. Now, you want to be cautious about how you go about reporting it, and we can talk about that. But again, that is, if I put it in very simple terms, if you don't report it, you potentially subject yourself to discipline for 2 violations of Board of Pharmacy rules and regulations. 1 for failure to report, and 2 for whatever the substantive underlying disciplinary action was attributable to. The moment you report it, they no longer have an ability to discipline you for not reporting. So you take potentially 2 causes of action down to 1. That in and of itself is a small victory. Now, the next one, failure to operate. This is another one that I have seen very consistently throughout the country in some way, shape, or form. Right out of the gate, I will tell you, in my experience, many pharmacy owners and many pharmacists are not aware that once you get a pharmacy license, you are on the clock to get your doors open to the public so that you can engage in the business of pharmacy. This is essentially, you can get in trouble for not doing anything. To give a little idea here, the reason why the boards of pharmacy are concerned about this is because they want to make sure that if a Board of Pharmacy website reflects that there's a licensed pharmacy at a particular location, that if a patient goes there, that they will be able to get their prescription drugs. They also want to make sure that patients aren't mistakenly believing that there's a pharmacy on the corner that they can go into to get their prescription filled and dispensed, only to go there and find out that it's not open and operational. So, I'm using Texas as an example here. The Board of Pharmacy can discipline a licensee if the board finds that the licensee did not engage in or cease to engage in the business of pharmacy. So this is a two-part. One is failure to engage in the business of pharmacy is defined in Texas as the licensee did not begin operating the pharmacy within 6 months of the date the license was issued. This is significant. And I'll just quickly get to the cease to engage in the business of pharmacy. That means discontinuing operating the pharmacy for a period of 30 days or more unless the pharmacy experiences a fire or disaster, in which case the pharmacy must comply with section 291.3G of this title relating to required notifications. And I just made a note, quick detour, back to failure to report or notify. It all goes back to these notifications. Even in instances where you have a fire or a disaster or some seemingly legitimate basis why you could not operate, you gotta tell the board. Now, there's a lot to talk about here. First, how is business defined? This is probably one of the most frustrating things for pharmacies and pharmacists. It is not enough to be open. Being open does not mean you're in business. The way that in Texas, in most other states are the same way. They monitor claims to determine whether you've engaged in a meaningful or substantive amount of pharmacy business that they would reasonably consider you to be engaged in the business of pharmacy. So it's not enough to be present at the pharmacy. It's not enough to have the front door open and unlocked. It's not enough to have the shelves stocked and be able to fill a prescription. You have to be actively filling and dispensing prescriptions. A couple of things I see here all the time. Pharmacies will say, I was open. I was brand new though. I was just trying to get started and it took a long time to cultivate the business. It took me 9 months till I was like off the ground and running. That's not going to cut it. What do you do if you're having those types of challenges? Communicate with the board. Let them know. I got my license on January 1st. It's now coming up on July 1st. You're concerned about being open or engaged in the business of pharmacy. Let them know about the challenges. Tell them what you're doing to address it. That is how you are proactive to avoid this issue. Second thing I see all the time, I don't normally hear the word, I had a fire or disaster, but I do often hear, we were in an area that got hit by a hurricane. There was nothing I can do. The thing you needed to do was tell the board, we were affected by the hurricane. We were affected by the ice storm. We were affected by the flood. Therefore, we are not going to be able to be open for business for the next 7 days. If for some reason it's going to be more than 7 days, we will touch base and update you and let you know. This is due to a disaster. It's out of our control. You got to communicate it. The last one I'm going to say that I hear all the time. Renovations. We were engaged in renovations. If you're renovating, tell the board. That's good. It's nice to have up-to-date, pristine pharmacies. But if you close down as part of that renovation process, the board's not going to accept that as an excuse to not be engaged in the business of pharmacy. So let the board know about the renovations. And then shifting over to inadequate supervision. And the reason why I included this as a common action is, first, it is common, but this might stand out as a little more distinct from the other ones, because I'm sure most of you might be thinking, yeah, I know that I have obligations under my pharmacy license to supervise my pharmacy staff. The reason I point this out is because in my experience, this type of a disciplinary action arises oftentimes in what I would describe as kind of more innocent, more of the oops or mistake. It's issues where a board of pharmacy representative arrived for an inspection and the pharmacist in charge happened to step out for a moment for a completely legitimate reason. So I've just included here a couple of pieces of inadequate supervision language here from the state of New Jersey. Or first, I would just say, we often see this issue arise. You don't have your pick in place after a pick leaves the pharmacy for a legitimate reason that I'll be right back. Inadequate supervision for seemingly short periods of time. This could be two-part. One for the I'll be right back, but the other one is going back to what we talked about earlier. You have the pharmacist in charge that unexpectedly quits and you can't find a replacement and you don't report the issue to the board. You're going to have pharmacy didn't have a pharmacist in charge, and also potentially an allegation that there was inadequate supervision. It could be one or it could be both. And then another inadequate supervision issue that we see is pharmacy to pharmacy technician ratio. They vary from state to state, so I would just encourage everyone to make sure you know what the ratios are for your state. And these things, again, I see these oops moments all the time. You're completely compliant, but you have a shift change. And perhaps someone shows up early because they're a very good employee. And for a brief moment in time, you have, and I'm just making up numbers, you typically have 2 pharmacy technicians that you're supervising. And for a 10-minute period of time, it's now 3. And it was a 1-to-2 ratio in your state. And oh my gosh, an inspector arrives for an inspection. And the first thing they see is pharmacist in charge is supervising 3 pharmacy technicians, not 2. Inadequate supervision. Do these things happen? Yes, they do. I'm not making them up. So in New Jersey, we see a definition of immediate personal supervision, the pharmacist being physically present in the pharmacy area when interns, externs, and pharmacy technicians are performing delegated duties. And then just a little bit about the pick and their duties as a pick in terms of the number of hours they need to work per week, so on and so forth. Again, it goes back to making sure that you have a pharmacist in charge in place and that you're accounting for any types of gaps in time, the unexpected quit, or someone needs to take time off unexpectedly or for any reason. Now, I've talked about this throughout here, but again, common reasons for these actions. Usually what we see are generally the category of complaints. Who do they come from? It's typically patients, customers. I would also say concerned citizens. You're a new pharmacy that's trying to get up and running, and perhaps the local neighbor that is curious tries to visit the pharmacy, understands that it's open, but in the first several months it's not open, so they might submit a complaint. Hey, new pharmacy opened in my community, but every time I go there, they're never open. What's going on here? They will look into that. And then the other thing is the random inspections, the drop-in. And then one other big source of complaints, and yes, it was bound to come up, is PBMs. PBMs, if they observe something in their minds that is a cause for concern, they will report it to boards of pharmacy. And I should probably pay a little more attention to that, but we will talk about it throughout the series. But the reason I'm not is this is really about the boards of pharmacy. It's not about PBMs today. But I do think that that is something you need to keep in mind, is that I would say that PBMs, for better or for worse, kind of have a reciprocal relationship in some ways with boards of pharmacy, except that I would say you're far more likely to see PBMs talking to boards of pharmacy than boards of pharmacy talking to PBMs. And so as we're getting close to the end here, we can take any questions that you may have. And I do have one additional question. So a question that we have is it the pharmacy's responsibility to report discipline on the license of a staff pharmacist to all states in which the pharmacy is licensed? And the answer is, it depends on the state. Some states will put the obligation on the individual pharmacist. Some states will put the obligation on the pharmacy itself, and some states will put it on both. I would say you should assume that both the pharmacy and the pharmacist have the duty to report disciplinary action to every state in which they are licensed. And if for some reason it makes more sense, if you have the time to review, or alternatively, if you want to hire legal counsel to assist you with the process, which you might do because it could save you time and perhaps money and efficiency, then you can say, well, do I have to in this state, that state, in this state? And you may find that for some you don't and some you do. But generally speaking, you are going to need to report disciplinary action to any state in which you're licensed, whether it's the state, whether it's the pharmacy or the pharmacist. The other thing I would say too is keep in mind that under most of your payer contracts, you're going to see similar reporting obligations. And what I would say there again is the better approach is to report these things in a timely manner and deal with it based on the reporting in a timely manner, rather than hope that no one finds out about it, because the likelihood is that people will find out about it. And it is much easier to explain it in the context where you control the narrative and where you have reported it in a timely manner, rather than asking for forgiveness at a later date. So we're just at about 50 minutes, and I think that's it. So I would just say the reminder is on this first series is to just keep in mind the importance of being proactive. And as we move into the next series, we're going to focus much more on things that you can do, examples of being proactive, and how it goes about helping to avoid any action. A couple of things I just want to mention as we wrap up. Tomorrow is going to be a big day for Frier Levitt, because if you heard about this webinar, you may have heard about this because we did do an announcement on this. But Jonathan Levitt, who is one of the co-founding partners at Frier Levitt, is going to be testifying before the United States Senate Committee on Finance tomorrow. And the topic there is perhaps very apropos to all pharmacy owners and pharmacists, but the topic is pharmacy benefit managers and the prescription drug supply chain, impact on patients and taxpayers. So I would encourage you all, if you have the time, I'm sure you're all busy, but the hearing begins tomorrow at 10 a.m. And there is a link at the U.S. Senate Finance Committee's website that you can watch it. And I can tell you that there's going to be a lot of topics that if you're a pharmacy owner or a pharmacist that are going to be discussed during the hearing tomorrow that will be of critical import to you. So I would encourage you all to tune into that. And then I would also invite you to tune in for this second part of this webinar. We'll keep it right around the same time, 45 to 50 minutes. And with that, I don't believe there's any additional questions. So I would just thank you all. If you have any questions that you didn't ask today that you would have preferred to ask but didn't for any reason, please do feel free to reach out to me directly. My email, my phone number, it can be found through Frier Levitt's website. Thank you so much.